Hi, everyone. Welcome back to Immigration 301. This is our series of conversations that we have with experts to break down the most complex situations evolving in the immigration landscape. And I am so excited for this conversation because the immigration headlines have become incredibly noisy. And over the past year, we've seen proclamations and agency guidance and fee changes and enforcement shifts. And sometimes we see headlines that we make things to be a much larger deal than they actually are. And sometimes there are policy shifts happening that we aren't even aware of. But I have Jesse Bless here, who is one of the country's top immigration litigators, and he is going to unpack a lot of what is happening today for us. So Jesse, thank you for being here.
It's my pleasure, Danielle. I'm happy to, simplify the complex if I can, and again, talk through some of these big cases and maybe even some smaller ones.
A lot going on.
There's a lot going on, so we can just dive right in, and
Awesome.
I'm happy to take it from your lead.
Amazing. And what I'm really hoping to do here is to demystify a lot of the litigation with you. Not theory, not law school level, but really we have employers and attorneys and foreign nationals who are just trying to cut to the core of what is happening right now. And I'm so excited to jump in. And for those on the call and who are here live, Jesse and I have known each other a long time because he actually worked with my father, Jeff Goldman, at Goldman and Partners Immigration Law, and has always been a very creative thinker. So I'm sure, Jesse, that's part of your story and your litigation strategy.
Yeah.
But would love to actually start off by asking a question of how you ended up doing immigration litigation and in this niche, because
Yeah.
there's tens of thousands of immigration attorneys around the country, and you are here fighting the fight on behalf of so many of them. I think it's interesting to start there and just learn a little bit about how
Sure.
you ended up here.
Yeah, it's actually it's an amazing story. Like most people who are old, like myself, my first 2 weeks of law school was September 11th, 2001. I was a kid from Boston, Wakefield, Massachusetts, and I happened to be in North Carolina at Wake Forest University for law school, and it really just changed my focus and outlook on maybe what I was supposed to be doing, and I was dedicated to serving the public. And at that time, the Department of Justice had an honors program, and I was fortunate enough to get selected. And I actually did employment discrimination based on people's national origin. That was what I was assigned to do. And then I started prosecuting domestic violence cases actually for a while in DC, which was my first experience into trial litigation. And then it just so happened that the head of the Office of Immigration Litigation in Washington, D.C., went to Wake Forest. And immigration was hot then. It's very hot now, but it was hot then. And I got assigned to that office. And I worked there for 13 years. And it's funny enough, it's how I met your dad. Because I was married and I had small children, and I was trying to get home. And your dad and I had met when he started his own firm. And we stayed in touch, and he stole me away out of the swamp, I guess, in 2017. And I was fortunate enough through your dad to work, and we worked on one of the first cases that challenged really this kind of disappearance of the children. And I know that was a fundamental shift in your dad's lives and your life and my life. And through that work, I was selected to become the American Immigration Lawyers Association's first litigation director, and I jumped back into service and had some success during Trump 1.0, beating back some policies. And then no one wanted to hire me anymore, so I had to start my own business. And so I just
Good push.
I get to control my little shop, and I'm blessed to have just a great paralegal myself. So I do all the big cases still, and some of the smaller ones, and happy to unpack kind of what we see right now and where we're going.
Amazing. I'm jogged back to those days when you were working on that case, and we were meeting these mothers who were separated from their children, and we were trying to tell their story, and you and I were filming, the moms that you were picking up at the airport. This has been a wild decade of uh that was also under the Trump administration one, where we started collaborating in that way. And it's amazing how, a lot of that is happening today again in just a different form. And we're really talking about employment immigration on this call today and not going into that so much. But it was,
Yeah.
I mean, that was, I actually think it's amazing if that was the start of all of your, the leadership nationwide for you.
Yeah. I mean, and it was. And I think that, the difference between, just the big difference between Trump 1.0 and Trump 2.0 is, and to be honest, they learned a lot. And I don't want to say they're more skilled, but they're
Yeah.
definitely more focused, and they're taking aim at the employment side because Stephen Miller has convinced people that certain forms of non-immigrant workers are not in our national interest, and combined with Rubio's barriers at the State Department, they've really done a lot of harm. The $100,000 fee case is a perfect example for H-1Bs, and we're getting ready to argue that case tomorrow, actually, in San Francisco. I know. And but just to step back, I think one of the things that needs to be said is federal court now really does represent the forum that you need to go to really voice your concerns, or on behalf of your employees, on behalf of a policy. There's a lot of rules being issued. There's a gold card program that kind of came out of nowhere. There's this $100,000 fee. And so anytime, a lot of the lawsuits, or almost all of them, are going to be brought under the Administrative Procedure Act. And what we're looking for is this kind of a final agency action. Right now, they've paused work for 39 countries, and then the State Department's done the 75 ban. But I mean, what you're really looking for is final agency action, and you really do need to show that the policy is arbitrary, capricious, or unlawful. And a lot of them are. At the same time, the president does have an enormous power to suspend entry of people, and that's what that $100,000 fee lawsuit's about. So we can talk about those, but a lot of the issues we're seeing is Congress. It's really, I mean, if you read the tariff case that just came out by the Supreme Court, they really did tee it up across the board. We have a president who's very active at changing the rules. We have a Congress that's not interested in legislating. And then we have courts who are forced to, tell the president when his power is at its end. And I think judges are being forced to check the president's power, and Congress is definitely not interested in or not able to pass new laws that may fix some of these issues that we see in our employment system.
Can you take us through the process from what the president's tactic has been in the last year in terms of launching the variety of rules or policies or various proclamations, and when the news picks that up, and when we should be reacting and assuming that this is actually the way that, that will be implemented? I mean, companies are on the receiving end of this, right? There's a lot being launched, and there's a lot that's being launched in a way that is not legal or potentially legally binding. And so how should companies who are, planning hiring practices and figuring this out, how reactive should they be to the president's proclamations and the process he's taking?
Yeah, I mean, I think it's really hard for anybody, including myself, to really get off your timeline, or get off, the news cycle and the pings on your phone. But the H-1B fee is a really good example, I think, of somewhat the inability to control, and then how do you focus on a chaotic situations.
Right.
That
Yeah, let's
drops.
start there.
Yeah, that drops on a Friday night. We got people like on planes. We have the CEO of Microsoft telling everyone not to travel. And it's supposed to be effective Monday. They're talking about it applying to new petitions. Then there's agency guidance that drops on Sunday from CBP, the Department of State, and USCIS, and none of it is consistent. And so as an employer, I think it's really difficult. And I think, did anyone make a mistake? I don't think you can make a mistake when, you're telling your employees to kind of stay in place and, like, let's just let it sit. and you know that courts cannot get involved immediately. It's going to take time. I do, and then what's incredible is 3 weeks later, we find out after some people have left to renew their visas that it doesn't apply if you get a change of status or an extension of status for an H-1B, right? Or you can now come in on a B-1 or an H-4 and then file here, and there's a workaround. And all of that guidance is not in the proclamation.
Right.
And so I think a lot of companies that were reactive then had to change again. And to be fair, I'm not so sure USCIS was really sure about how to collect the fee, when to do it. I mean, they started issuing RFEs. So I think the best lesson is, we are going to have to kind of put together this parachute after we jump out of the plane type situation. Like, we're
Yep.
not going to have it fixed. And with this administration, unfortunately, a lot of policy does get dropped on social media, and we're left to kind of just, again, I don't think you want to respond to this chaotic situation with more chaos. I think we just have to kind of, okay, sit and somewhat wait and deliberate. But, there are some overarching themes. The H-1B program, the statute is very specific. He can't overwrite the statute.
What is the statute that he cannot overwrite?
Well, I mean, there's the H-1B program that's at like 1180 USC 1184. The number of allocated visas every year, the cap exempt, the process. He's trying to change the fees, but there are specific fees that they've articulated. I think, who's cap exempt. He's certainly, well, one thing he's done or they've done through notice and comment rulemaking is how they're going to select people in the lottery. So I don't want to make it seem like he can't put up barriers. We're seeing states now put up barriers. But I think if companies are saying, well, we're not going to do H-1s anymore, that to me is a forced error. I don't think you need to do that. I think you just have to understand what the rules are today, and how they're going to be selected in the lottery.
So let's dive in here a bit,
Yeah.
Jesse, because a lot of the companies that are going to be joining this webinar today and who are watching later are filing H-1Bs actively and are folks, coming from abroad who typically enter on a H-1B for the company and are waiting to see what happens with this litigation against this proclamation. Can you give us the status? We've heard of various cases that have been filed. Which one are you involved with? What are the core arguments that you're making tomorrow?
Sure.
And where do you think this leaves us in this lottery season?
Yeah. So number one, the proclamation is supposed to expire, and it hasn't been renewed yet. And it's supposed to expire before next October. And so the president is going to have to reauthorize the $100,000 fee. So that's number one. So it could die on its own, but let's assume that it's going to be renewed. So there's two cases, at least two cases. Actually, there's more than two, but I'll talk about the big two. I represent a class action that's filed in the Northern District of California. So when you hear class action, if we were successful tomorrow, the judge rules in our favor at some point after that, you're probably going to be a class member. And so it would apply to you. That case is called Global Nurse Force Free Trump. There was another case filed in DC. I think it was the Chamber of Commerce. Well, I know it was the Chamber of Commerce, and then the American Association of Universities or something like that. And that was unsuccessful. And tough judge, tough arguments. Ultimately, I think a decision that's vulnerable, and they appealed, and they have an argument March 9th on appeal. In between that decision, the Supreme Court came off in the tariff case, and that was last week. And we think that why that's so helpful to us is that this fee really does represent a tax on employers who now want to sponsor workers for H-1B visas. And it's really tough to say otherwise. Yes, they're trying to say that it's a suspension or restriction on someone's entry, but you're really penalizing the U.S. employer who's already paying the fees for the petition. And so it's really not an entry restriction. It's really a tax or tariff to sponsor somebody for an H-1B visa. That's really a core argument that we're making, and we hope to be successful. Another one we're making is Congress was very specific about certain fees that employers have to pay. Everybody pays an extra $500 unless, there are some exceptions, but for a fraud fee, or they
Yeah.
call it the acquia fee. So you're already getting charged. Now,
And
argument,
dependency fees.
right. And our argument is that, just like the Supreme Court just said, listen, if Congress has been specific, it has, you can't just increase the fees on their own. And we know that they have before, but every time the executive agency has changed the fees, they've gone through notice and comment rulemaking.
Mm.
And so one of our arguments is that if you want to change the fees, you can't do it overnight. You have to go through this process, which allows for employers to share their concerns through comments and organizations to chime in. Another one of our arguments, and I think this is what separates maybe us from maybe the chamber case, is we think there's a real problem with how this has been implemented, because the Supreme Court was very, very strict about the president's power to restrict someone's entry. Entry is something that happens at the border, but the way USCIS has done this is they're implementing it at the petition stage,
Right.
which is well before somebody gets a visa, which is difficult. And even when you get a visa, it doesn't mean that you're going to you're not going to enter. By imposing this fee at the front end, this implemented it to charge at the beginning is unlawful. And that's another one of our strong arguments. We have
Even just having the USCIS handle this in general versus the State Department in terms of the fee, when the fees are due in the process and at what stage, that signifies that it's not part of entry. It's actually part of our.
Yeah, I mean, they're really trying to just change the eligibility criteria for an H-1B,
Right.
Worker. Oh, and then the other part of it is how I know a lot of people think that this exception or guidance to have it not apply to change of status, and that there's also this supposed to be a national interest exception
Right.
that is available. And we're unaware of anybody who's gotten that exception, and the government hasn't cited us to any approvals. The only thing they said was that this, and listen, I'm sure it's a great company, but their best evidence was that the CEO of NVIDIA thought it was a good idea to charge.
Yeah.
And that's what we're dealing with. And we represent, our plaintiffs are hospitals, unions, teachers, small employers, and big industrial employers. So we really do, we worked hard to make sure we had a cross section of the H-1B, businesses and organizations, exempt, cap, subject, to really to tell the story that this $100,000 fee is a death penalty for many people. Again,
Does it matter, Jesse, that in the, when they first put out the proclamation, they were pretty clear that there would be a waiver, and they even mentioned at points doctors and nurses. And we actually at Open Avenues Foundation put together a very robust national interest case and filed, sent it to this email, and it was a black box, right? Like there's nothing, it didn't go to anyone no one looked at it. I'm sure that we're not alone in trying to, our education exemption that we're training and getting jobs for U.S. students did not, we thought maybe that's something we should try. But as you're saying, like, is that legal? I mean, can you just come out and say that you're going to provide an exemption and not even monitor these kinds of things?
Yeah, or come out like I think the Secretary of DHS did and say, don't expect to get one of these. It's going to be a very, very high standard. I hope we don't have to get to that point, because hopefully the judge sees that the president really can't impose, or change the fee structure and make it a condition of eligibility, and understand that he's really penalizing U.S. employers. A lot of the hospitals and nursing facilities are in rural areas, and the teachers, I mean, really, if you, not that we can challenge, one of the problems with the president's power, which is big, he has a lot of power, is that we really can't challenge his wisdom. I know, others out there are probably smirking at me, but the whole premise of the proclamation was he was really upset about staffing companies abusing the program. And number one, the data he cited is really junk science. But other than that, I don't think they showed an appreciation of just the different types of organizations and employers that use the H-1B system and the benefits they get. I mean, just public school teachers and organizations like that. So we have an amazing legal team. I mean, I play a very small role. I'm happy to play it. Big argument tomorrow, obviously, and hopefully we can prevail. And it's a.
How soon could things change if you do prevail? And what
Yeah.
does prevail mean? What?
Yeah, so we've asked the judge to vacate the fee on a class-wide basis. So he has to certify a class of H-1B employers. He would have to vacate the proclamation. The government's probably going to try to appeal, but the fee should go away, and not apply. And really what we're hoping, I think everybody on maybe who are, getting ready to file and register people for the lottery is that, this petition wave that's coming. Hopefully, you're not, being asked to pay $100,000 to file these petitions. And that's our goal is to make sure that happens. We really wanted an order before registration began. I don't know that we'll
Right.
get it. I think, um, I think you're going to have to register it and really. Hopefully, the judge knows about it and issues his ruling and it's favorable. But I mean, I don't know if they're going to seek review. I think they probably will. And so what's going to be critical is not only that we prevail, but hopefully the DC Circuit in the Chambers case also reverses and says, well, after the tariff case, it really does show that the president's authority to impose a tax is really not available.
Yeah. Right. So if this does prevail, we have at least 3 companies that have asked us to file cap exempt H-1Bs and pay the $100,000 fee.
Yeah.
Would there be a return of those fees, or is this more moving forward?
Yeah, that's a really great question. I mean, as I'm sure you've seen with the fallout with that tariff case, I mean, once you give the government money, it's tough to get it back. I had a case recently for EB5 investors. Those are investors who pay,
Yeah.
upwards of $1 million. And we actually struck down the fees that they had been charging from 2004 until this year. And the difference was substantial
Yeah.
for the regional projects, millions of dollars. They were not willingly going to refund that money. So you may have to sue to get it back,
Yeah.
unfortunately.
And do you advise that companies right now, given your case and given, decisions that might be made in the next couple of weeks, are you advising that companies go ahead and put all of their registrants into the lottery, even those that they aren't willing to ultimately pay $100,000 for?
Yeah, I mean, I know the costs are higher, but I mean, there's still a benefit. You're not gonna, I think the optimist in me would say, yeah, let's do it. Let's see if we get selected. I think the numbers are gonna be low. So if you're willing
Yeah.
to give yourself an opportunity and get a critical worker, it may be to your benefit. Yeah, again, yeah, you're right. I think let me just give you a scenario that I've proposed that I don't share with many people, but I'll share it. I actually think that the implementation is the most egregious violation of the law on how they. So I don't think they can charge employers on the front end. I think you have to. I think they have to adjudicate the petition. I think the person has to get a visa, and I think at the time of entry they have to charge. And so between there, between here and there, if that were to happen, and USCIS has to redo how they change their fees, they may give up on it. They may not extend it. So I would, if I'm an employer and I can't find a worker and I have a great candidate and I have the opportunity to register, but it's limited, I would absolutely register. Yeah, absolutely.
That's really interesting. I think that's helpful for a lot of companies who are unsure of how to proceed right now. And I'm very curious what those large, the Tata consultancies are thinking right now in terms of whether or not they're going to put their folks into the lottery. I mean, it seems like you have some great arguments here. And one of the questions that we have is, do you think, what's your opinion on this particular judge and how favorable or unfavorable do you think they might be on this case compared to the Chamber of Commerce case that
Yeah.
was denied?
Yeah, I mean, Judge Howell, in the DC, in the District of Columbia, I mean, I listened to the argument and I have a lot of respect for her and all the judges. I think they try to do their best work. I think the Chambers case, I think what was surprising, and this is just what we deal with now, there wasn't a lot of evidence from companies. And I think she kind of got hung up on that. And they started fighting over maybe the wisdom of the proclamation. And the other thing was there really wasn't, because it was the chamber, there wasn't kind of a showing that maybe the depth of the H-1B program into our workforce, into the global, the U.S. economy. So again, I give them a ton of credit. They went first. They took their best shot. I think our case is so much more developed on the papers. Like we've given the judge a really good view. It's pro bono. I think the judge always is wants to know that. I think we're doing it because we support the program. We don't have a financial incentive. At least I don't. You
Yeah.
know, and the other thing, I think our judge, I mean, his name's Judge Gilliam. He's in, I don't, I think he's a George W. Bush appointee. He, from what I know, and, again, I have tremendous respect for anybody who puts on a robe, but he is going to absolutely be prepared. He's going to read everything. And he, from what I know in his prior rulings in immigration cases, is he takes the words of the statute very seriously. So for those who just read Judge Gorsuch's concurrence in the tariff case, that's the judge I think I expect to see, which in my mind leans favorable for us, because what the president and USCIS have done is manipulate the statute, in my opinion, because
Mm.
they're trying to change entry and restrictions to impose extra fees on US employers so that they either don't fulfill or don't hire H-1Bs, or only hire those that can change status. It doesn't make a ton of sense. And the other thing is they're solving a problem that Congress already solved. I mean, the employers already pay to protect the American workforce and to
Yeah.
protect against fraud. So what is this other than a tax?
Right. Completely. It's really interesting. And I mean, there's a niche situation we have where I just got a question about this because I know there's a few folks here who represent or are an employer for Open Avenues Foundation. We are in an interesting situation because we have concurrent employment. So we have two petitions filed out while people are outside the US.
Yeah.
And the question is, whether or not you owe that entry fee once or whether it's per employer. And there's not guidance on that. But just, I mean, if you have a take from digging in as much as you have, really curious to hear it.
From what we understand, it was supposed to be per petition.
Right.
And they've issued RFEs when they want the money. And when you go to a visa interview, if the State Department thinks that you should have paid, they're happy to tell you that they're not going to go forward if you don't pay. So I think it's per petition, but at the same time, I'm not so sure they thought at all about this situation.
About these niche situations.
Yeah.
Exactly. We've figured, we have a few employers and we also have the ability to create more robust programs for people to enter on more than just 5 hours a week part-time,
Yeah.
and doing one entry, obviously, to work for us and then file concurrent once individuals arrive is something we are discussing. But plan A is that the litigation is successful tomorrow, Jesse, and that we can again work with. I mean, we've had, just for like anecdotes about who this is. I mean, you're working nonstop on this, but we have helped, a biotech company in Boston bring their chief medical officer over who developed this scientific revolution and was coming over to build it with them, but didn't have enough qualification for an O1 because it was just brand new, hadn't been published yet. And that's the kind of person that we are talking about here. And I think there's not a contemplation for some of those types of incredible candidates in this blanket fee.
Well, I mean, a running theme of the whole Trump 2.0 immigration policy is there's really no distinguishing between somebody who's come here and done something they shouldn't have done and somebody who's coming here to create jobs for others, which a lot of H-1Bs ultimately do. I mean, it really is the life force of a lot of industries, and especially emergent industries. So it just seems to, unfortunately, Stephen Miller has a nativist view and wants to see zero immigration. And I don't know him personally. I wish I could speak to him, and not that I don't think he'd listen, but I think there has to be an understanding of some of the positives that the system has within it, and that their definition, everyone, I think, I don't really mean to like make light of it because I represent a lot of people who are detained, but they had this theory that they were going to just go for the worst of the worst, except they didn't tell you that the worst of the worst was everybody who wasn't a citizen, or actually, or everyone who was not a citizen and then also disagreed with them. I think, so again, the economy actually has held together a little bit But I think it's, the jobs numbers are starting to get a little soft and employers are starting to actually find their voice. And we didn't see that initially because they were getting bullied. And as their workforce really suffers and they can't get the products, and then they had success on the tariff cases, you saw FedEx sue for refunds. We need more of that to tell them, just exactly what companies need to help our economy in the United States. Because if we lose these workers, the economy is really going to suffer.
Yeah. Are you working with corporations that want to sue? Is that part of your realm? Are you?
Yeah, I mean, I represent a lot of companies all the time. Not so leaving the H-1B context. So a lot of L1s, executive and managers, or specialized knowledge employees started to change a lot. The standards that they were applying, companies are starting to put their foot down, suing over that. B1A exceptional ability or O1 exceptional ability, everything's getting tighter. So self-petitioners or companies are definitely funding litigation. And
So you're
then,
saying when there's a denial or when there's
yeah,
like a wrongful denial, or if someone is, they feel like they specifically in this have been wronged on this one case, our companies are coming to you and saying, we want to take action.
100%. Or they're telling their employees to get. And I mean, I'll give you an example. Is we have right now there's a pause policy by USCIS after a couple of incidents in Washington D.C. where unfortunately an immigrant shot a National Guard member, and so USCIS put a halt if you're from one of these 39 countries that they've tested. And I can't tell you how many people fall into that category who work at the Apples and the Googles and hospitals across the country who are in limbo now because they can't get an extension or an OPT or anything. And so they can't work. They are susceptible to being picked up and arrested. And, you know, we're involved in that. And we represent about 300 people in that, but companies are really starting to see that they really don't have they don't have a choice but to speak up because they're losing emergency room doctors and teachers,
So diving into the travel ban in these 39 countries and then 75 countries that have had travel restrictions, what is the status of litigation regarding these restrictions, that these are being felt by companies in a variety of ways? I mean, we have someone that we've petitioned for from Nigeria and also from Venezuela. And even though we are hearing that, of course, it's written that these are immigrant in cases that are being paused for the time being, even for a temporary work visa, we are seeing just these RFEs in holding pattern beyond premium processing for some of these countries. So want to understand, what you're seeing and what is possible for litigation there.
Yeah, I mean it's out of control. I mean, I'll tell you. So there's the USCIS. If you're in the United States, there's USCIS has their 39 country pause or whatever it is. It's a lot easier to sue USCIS. Just all things being equal, the people are here. They have benefits pending. They're in the United States. Something has to be done. When you're outside the United States, of course, and you're asking for a visa, the Department of State doesn't think they can ever be sued. And then, a lot of times if it's a 212F proclamation, like the fee, they're using that to say that the person is ineligible for a visa. So think of like an Iranian student, they would say, well, the president has suspended their entry. So that means that I can't do anything on the visa. Go away. On the 75 country, like public charge, that was Rubio's attempt to rewrite the statute. And that one really is unlawful. I understand, Marco's trying to he doesn't want people to come in and take advantage of, benefits and all that, but Congress already really took care of that. There's a provision in the law that 212A4, and he's really just trying to stop immigrant visa processing for people, and it really doesn't apply to a lot of people. And so the DOS litigation, which is ongoing, that is more about, hey, can the president just restrict the person's entry, very similar to the H-1B lawsuit. But there's a little nuance in the argument, which is if the president does have this power, can the State Department just put their pencils down? And the answer should be no. They should process the visas, because I know, like India right now, people are struggling to even get appointments for years, and they have to hold on to them. And the State Department should continue to do their work, because entry is something that comes after. The litigation against the State Department, difficult, but there's good arguments there, especially on the 75 country, public charge kind of issue.
The status of it, timing wise?
So there are multiple cases. Our cases are probably going to be all coming up for decision between, in March or April. There was one case already that was successful against USCIS's suit. It was about an adjustment of status. And then the judge said that, the USCIS had no explanation for how it came up with the policy, and it looked discriminatory, which it is, and that she actually ordered them to adjudicate. It was a green card application. And I'll tell you a story to be, just to give you a little purview into my life. I actually had an Afghan, someone who had worked with our armed forces, who was going for his citizenship. And we were in litigation to get him sworn in when this policy started. And I can tell you that the U.S. Attorney in New York and I both were emailing, like we were like buddies from high school, being like, oh my God, like, no way, like this cannot happen. Because we had just worked out an agreement where he would get sworn in. And I'll give him a ton of credit. And this is why litigation is sometimes valuable, so you can talk to a person and get your voice heard with an actual human being. Because he listened. I was like, oh my God, we got to do something. And even though there's this pause in place, and he was an Afghan national, he's now a citizen. We worked it out.
Wow.
But I'll tell you, you have to go all the way up. But there's no way. I mean, I don't want to like put too much, like, I don't want to like pat myself on the back or anything, but like that person honestly could have been detained, and now he's a citizen. And again, I think I'll give all the credit to him, because he had enough guts to trust me to get it done. Again, I still think there's things that can be done, even though there's this pause.
Jesse, when there are these, I mean, first of all, amazing work. And it must, you have these massive cases that are class action, and then there's these small cases that you just feel the impact immediately, which is an incredible way for immigration attorneys to be able to get motivation to keep moving, to make these big arguments. But when you have these small successes, is there precedent built that then can be taken and used by other companies who have individuals in similar cases? And is there a way for those companies to gain visibility into that precedent?
Yeah, the way I like to work is I like to make it not precedent. Like for this person, we just worked it out, and we didn't go to the press. We didn't do anything. We just he wants the citizenship. Let's do it. Obviously the DC circuit case, when that case comes out in the $100,000 fee, that's going to be precedent, a circuit court decision precedent. Hopefully it's a favorable one. But these cases, sure, we can use them. I think a lot of times employers need to understand that, the right question to ask is, hey, because they don't want their name on a precedent decision. They want to get this one thing done. And a lot of times it's, what are the chances that you're going to be able to work this out? And I don't want the judge to have to make a decision. And just so everybody knows, and this is helpful, I always get this question. So what happens when I sue? Well, after you sue, you have to serve the complaint, and then you get 60 days. And then that 60 days is really like a negotiating window, where if you have a specific problem, a denial, a delay, they didn't receipt in your application, you can work it out. And that's a magical period, and we want to use that to our advantage. And so hopefully if we win there, there is no precedent. So, I'll give you another, just little story. So there's a person getting his PhD who went on a school trip, and they went to China. They went to China. He's not from China, but he should have known not to do that, because he's a foreign national. Why is he over there? And so the State Department got nervous. He had been in the United States in Boston for like 8 years. He's engaged. He spent 2 years in Mexico. We sued just for a decision on his F1 visa so he could get his PhD completed. And we worked it out. We ended up working it out. They were going to move to dismiss, but I was, again, part of
Yeah.
the human element is telling them why it's better to just
Yeah.
squash it, you know?
So some of this is like, for companies on the call or attorneys on the call, some of this is case by case basis, needing to just fight the fight, right? And
Yeah.
having to fight on a behalf of an employee or someone that is put through the ringer. And obviously that's not sustainable for companies in terms of strategy, which is why there's obviously a lot riding on these decisions in March. It seems like all of them are in actually March, which is going to be a really interesting month because the lottery will close. And if people don't have their registrations in and it comes out that the bans are, no longer in place or the, $100,000 fees no longer in place, then companies will then have an opportunity to bring those folks in. So it's probably ideal that they at least get those registrations into the lottery for those folks. I know that's only H-1B and the travel bans are affecting
Yeah.
everyone right now. So they can definitely get those petitions in for O-1s, et cetera, at that point. But this is all coming to a head right now. So you must be drowning, Jesse. This is a lot right now.
Yeah, I mean, yeah, it is and it isn't. I think I mean, immigration, unfortunately, is something now that the it's on, the ground keeps moving under our feet. I will say, I try to, the best thing I can say for companies is I'm sure they're seeing a lot of approvals on other things. There are things that, the career officials do want to do the right thing. I would advise people, like, if there's an opportunity to comment on rules, it's important because if we were going to litigate a rule, sometimes we want to use comments that they ignore about why this is a bad program for you or, how this rule is going to affect you. And so a lot of times the companies can get involved in a positive way by making sure that they've put their comments out there and they've shown it. And I think it's
Is there
valuable.
any pressure on this H-1B wage rule that has been, that will be in effect for the next? I mean, I know that Amy Nice and this group, I think I saw someone on the call, Diane Risch was on the call who are working on a lot of those public comment against this
Yeah.
rule of the weighted lottery. But I know a lot of companies just, one, don't want to get involved, and two, don't believe that once a rule is published, that there's anything that can really be done, and it's a waste of time and effort. And can
Yeah.
you, from a litigation perspective, from the process perspective, like what can actually happen, and is it possible to overturn? Really?
Yeah, I mean, we've taken down a lot of rules. I mean, I just took down that 2024 fee rule for EB5. I think there's other rules. We took down the DOL wage rule when they came out with it in 2021 or 2020. It was a lot easier back then because at DHS we're not appointing people in the right process, and we could strip a lot of rules because they didn't follow their process. But from a comment perspective, if they don't have a fundamental understanding of how business works, which in my opinion, sometimes they don't have, like, they
Right.
don't understand that maybe you don't replace an American worker with an H-1B, or that the wage that they're now going to charge is going to make it so that you now cannot hire other American workers. They don't understand that. They think it's a zero-sum game. And so if you have a comment to add, it doesn't have to be elaborate. You can be like, hey, I work in the oil industry. And in fact, if I don't have this person with specialized knowledge, I can't hire the 10 people under him or under her. I think it's a valuable feedback because as a litigator, I don't know your field. I don't know your industry. But if they ignore your arguments and they don't take into account like reliance interest, that's another one. They should take into account, like, I rely on this program, I'm going to go out of business, or my fees are going to go way up. I think those are powerful arguments that litigators can use.
Yeah.
The other thing too is sometimes it's helpful to just get it off your chest.
Yeah.
Like, you're killing my company.
A venting mechanism.
I mean, hey, they don't let you do it with the
Yeah.
tariffs. And
Right.
I think it's important to not accept what we know to be untrue. I can't make the comments for people, but yeah, I think there's value in it for sure.
Yeah. I was listening to a podcast this week, and it was really a sum up of 2025, and they were talking about Trump and the theory in general and projecting out the next few years is that we will leave this administration having Trump been one of the least impactful long-term presidents in when we look forward 20 years and look back at his presidency because of the way that and the mechanisms he's using to implement policy and change. And I wanted to pressure test that thought with you. When we look at immigration today and we look at the mechanisms that Trump is using to make change, such as the H-1B changes to lottery and fees and, travel bans, et cetera, it's incredibly impactful right now. But if we fast forward to 2029 or beyond and look back, what do you think will have the biggest impact long in effect? And what do you think will
Yeah.
be able to be overturned quickly and will be impactful long term?
I mean, I appreciate the opportunity because I think, just as a personal situation, I only get bad news as a litigator. Nobody comes to me and says, I got my visa, I don't need you. So the way I've kind of framed it so that I can be my best self and improve is I really look at this administration. I try not to take it personal. I try to what is the value of what is going on right now? The value of what is going on right now is this administration is really pointing or shining a light at all the ugliness that we need to fix as a society. Immigration is one of those. We've let it go. I think the last attempt was in the 80s that really tried to reform. There has been some other legislation that has come out, but piecemeal. We need a total overhaul. We need buy-in from all the actors, business, family. We need to have a conversation that's a tough one about what we want the country to look like and how we want to enforce the border. At the same time, make sure that we stay at the forefront of innovation with AI and all these emerging technologies. Obviously, whoever wins that race for talent and then protects itself is going to have a leg up. And so we're really at a turning point. I think I tell my kids this all the time. My two oldest boys at 15, dad he's gonna wear the crown, really the crown of thorns, so that you guys can hopefully have it easy. And we're gonna go through some tough times right now so that you can not have to deal with some of the ugly scars and ugliness that we have to work through right now. And that's what we're doing. So I do think that this administration I think it's going to be absolutely remembered for a turning point because everybody now, I mean, I don't want to bring up an ugly subject, but we have people now like Ro Khanna and Tom Massey who, if you didn't know what they represented, what political, they agree. They're walking hand in hand. Nancy May, I mean, I know they're dealing with a different issue, but I think they're starting to show that there's a lot that needs to be changed. And immigration is definitely, if not the first thing, it's going to be a close second. And the idea, and every society that has tried this has failed. So if you close your borders, China tried to do it. It did not work out well. Europe tried to do it at one time. It does not work. It just doesn't. So we have to understand we also have a demographic problem. We can't be old. We have to replenish. And so there's a lot of smart things that need to happen with immigration. We need to strip the statute. We need to replace it. Employers need to have a seat at the table, and we need to actually say, what are your needs? How do we make this easy? How do we not have litigators have to litigate for you all the time? I'd love to be put out of work, to be honest, and I can go coach fourth grade girls basketball. And I think that's what we need to do. And we need to have people who actually understand the immigration system, who are willing to talk about some of the abuses, and at the same time, we need to actually find kind of the human value of all people and have a upfront conversation about who can come in and who can't. Because I know a lot of employers were really aggravated from 2022 to 2026 or, whatever, 2020, because they were like, why am I paying for an EAD and this guy's walking through the door? I can understand that. And I know that I do know this, though. Every day I talk to people on Zooms and I can see that they've either cried, not slept, or are willing to give up. And so, I'm not, my first role is to tell them that there's hope. And I think there's a lot of it. Sometimes, it's, your dad is great at this, just keep walking and, you find the light and we'll get there. And hopefully this next month, with the new season, we'll get rid of the snow and we'll get rid of this fee and you'll get your registrations done. But if we don't, you have to trust that ultimately the market is going to tell the president that his policies are wrong. And we have an election coming up in 2026, November, and I'm not a politician by any means, but there's only so much that employers can take.
Yeah. Well, thank you, Jesse, for fighting the good fight. It's clear how passionate you are about all of this. And I mean, it's pretty incredible what's just around the corner in terms of these big decisions. We will all be waiting, and hopefully we'll have you back to talk about some of the results of what this means. But you're kind of giving us the lens of no matter what happens, there is change at some point that we know as individuals and as employers on the call or immigration attorneys and, knowing the population of individuals we work with, we know what this means for the economy, and we know what will be shown
Right.
in 3 years as evidence if we can't pull off these lawsuits today. But I think I'm aligned with everyone on the call and everyone who will watch this later that we wish you a lot of luck tomorrow and just appreciate your efforts. And I'm sure many companies will also be reaching out to you because now you've told everyone about your incredible services on a one-off basis as well. So that's really helpful. And this brought a lot of clarity to the things that we've all been questioning. So thank you everyone for coming. Jesse, we will be in touch and I appreciate your time.
I love it. Thank you so much for the
Awesome.
opportunity. Be good.
All right. Take care, everyone. Bye.